Before we begin, a quick and important disclaimer. This video is for educational and entertainment purposes only and does not constitute professional legal advice. The laws surrounding domestic relations and matrimonial practice vary significantly by jurisdiction and have undergone massive shifts over the last century. This content should not be used as a substitute for consulting with a qualified attorney in your specific state regarding your unique legal or financial situation. We strongly encourage viewers to conduct their own due diligence and seek certified professional counsel before making any decisions related to legal proceedings. In 1925, if you were an American citizen living in a state like New York and you found yourself in a marriage that was simply dead, you had a terrifying realization. The law did not care about your happiness. In the eyes of the court, a marriage was a permanent contract that could only be broken by a sin so egregious it demanded a legal autopsy. If you wanted out, you didn't just need a lawyer. You needed a director, a private investigator, and a willingness to commit perjury. This was the era of the staged adultery photo. Lawyers would hire professional correspondents, women whose entire job was to be photographed in a hotel room with a married man, both fully clothed but looking compromised, just so a judge would have the legal grounds to grant a decree. If you both wanted the divorce, you were legally forbidden from getting it. This was called collusion, and if a judge suspected you were working together to end the marriage, he would throw the case out and force you to stay together forever. This is the hidden, often dark history of the American divorce attorney, a profession that evolved from the shadows of social pariahs to the architects of the modern American family structure. Over the next hour, we are embarking on a deep dive masterclass into how a century of legal battles, loopholes, and social shifts created the multi-billion-dollar industry we see today. We will uncover why the system was designed to be adversarial, how the Reno Cure changed the economy of the West, and why the transition to no-fault divorce in the 1970s didn't actually make things simpler, but instead shifted the battlefield from morality to math. By the end of this series, you will understand the DNA of the American legal system in a way that very few people do, providing you with a historical lens to view modern domestic litigation, asset division, and the true cost of I do. To understand where we are, we must first look at the legal landscape of the early 20th century. At this time, the divorce attorney was not the high-status professional we see in modern skyscrapers. In many legal circles, matrimonial law was considered dirty work. It was the domain of lawyers who couldn't find a place in corporate firms or white shoe practices. This was because the legal framework of the time was rooted in the concept of fault. To obtain a divorce, one party had to be the innocent, and the other had to be the guilty. The grounds were usually limited to adultery, desertion, or extreme physical cruelty. This created a paradoxical incentive system. Because the law required a villain, attorneys had to manufacture one if a real one didn't exist. This led to a historical trend known as migratory divorce. If your state's laws were too strict, your attorney would recommend a vacation. This brings us to our first major case study in the evolution of the profession: the Reno phenomenon. In the 1930s, Nevada realized they could capitalize on the strictness of other states. While New York only allowed divorce for adultery, Nevada allowed it for mental cruelty, a much broader and more subjective category. More importantly, Nevada only required a 6-week residency. Divorce attorneys in Reno became the most famous in the country. They weren't just legal advisors, they were travel agents and social coordinators. They would meet clients at the train station, set them up in divorce ranches, and ensure they stayed in the state for the required 42 days. This period represents the first time we see the divorce attorney as an economic driver. The city of Reno was essentially built on the fees of those seeking to escape unhappy marriages. Lawyers would advertise discreet and rapid results, a phrase that, while avoiding modern guarantees, signaled a potential outcome that was impossible elsewhere in the country. The role of the attorney during this fault-based era was primarily that of a storyteller. They had to weave a narrative of victimhood for their client. If you were a woman in the 1940s seeking a divorce, your attorney had to prove that your husband's behavior was so intolerable that it endangered your health. This led to the heart bomb era, where attorneys would sue homewreckers for the alienation of affection. It was a high-stakes, high-drama environment where the courtroom functioned more like a theater. The attorney's job was to maximize the guilt of the opposing party to secure better alimony or a larger share of the marital property. Because women often had no independent wealth or career prospects, the divorce attorney was quite literally fighting for their client's survival. This is where the aggressive reputation of the divorce lawyer was born. It wasn't just personality. It was a structural necessity of a system that required a winner and a loser. As we move into the post-World War II era, the social pressure began to boil over. The disconnect between how people lived and what the law allowed became a chasm. Historical trends show that by the 1950s, the staged divorce had become an open secret. Judges knew the witnesses were lying, lawyers knew the photos were faked, but the legal fiction was maintained because the legislature refused to change the statutes. This created a crisis of integrity within the legal profession. A generation of attorneys began to lobby for a system that didn't require their clients to commit perjury just to find peace. This advocacy led to the most significant turning point in the last 100 years, the 1969 California Family Law Act, signed by then-Governor Ronald Reagan. This was the birth of no-fault divorce. The promise of no fault was simple. It would remove the vitriol. You would no longer have to prove a wrong to get a divorce. You only had to state that there were irreconcilable differences. Many predicted this would be the end of the high-powered divorce attorney. If there was no guilt to prove, what would they fight about? History, however, shows us the exact opposite happened. When the fault was removed from the marriage's end, the conflict didn't disappear. It simply migrated to the finances and the children. The attorney's role shifted from a detective of morality to an expert in forensic accounting and child psychology. This transition is crucial for understanding the modern system. Today, a divorce attorney in the U.S. must navigate complex tax codes, 401k valuations, and digital forensics. The masterclass level of this profession now requires an understanding of how to value a business, how to trace hidden cryptocurrency, and how to argue for best interests of the child using social science data. In this first part of our deep dive, we have seen how the divorce attorney evolved from a fringe player in the legal world into a central figure of American civil life. We've looked at the fault era, the Reno divorce mills, and the initial shift toward no fault. But what happened when these new laws hit the reality of the 1980s and 90s? How did the tender years doctrine for custody give way to the best interest standard? And how did that change the way attorneys bill their time? In the next segment, we will analyze the specific case studies of the late 20th century, where celebrity divorces and massive corporate fortunes began to dictate the legal precedents we live under today. We will look at how the equitable distribution versus community property split across the U.S. created a map of legal strategy that attorneys use to this day. This is a century of conflict, but it is also a century of the law catching up to the human heart. Let's continue into the mechanics of the 1970s revolution. The 1970s did not just change the law, it rewired the American psyche regarding the duration of a commitment. When California Governor Ronald Reagan signed the Family Law Act of 1969, which went into effect in 1970, he inadvertently signaled the end of the private investigator as the primary tool for a divorce attorney and the beginning of the accountant as the ultimate weapon. Imagine if you were a high-earning professional in 1972. Before this shift, you could potentially block a divorce simply by being a faithful spouse. Under the new no-fault regime, your partner could walk into a courtroom, cite irreconcilable differences, and the legal machinery would begin to grind toward a decree regardless of your desire to stay married. This created an immediate and desperate need for a new kind of legal advocacy. The question was no longer who did what to whom, but rather what do we own and how do we split it? This transition birthed the modern distinction between community property and equitable distribution. To understand the attorney's role today in 2026, you have to understand this historical fork in the road. In community property states like California or Texas, the attorney's job became almost mathematical. The law presumed a 50-50 split of all assets acquired during the marriage. However, in equitable distribution states, which comprise the majority of the U.S., the attorney's role became much more interpretive. Equitable does not mean equal, it means fair. Attorneys suddenly had to argue the value of a homemaker's contribution against the value of a CEO's salary. They had to weigh the length of the marriage, the age of the parties, and the future earning potential of each spouse. Consider a case study from the mid-1970s involving a middle-class couple in New York. The husband had spent 20 years climbing the corporate ladder while the wife raised 3 children and managed the household. Under the old fault-based system, if the husband wanted a divorce to marry someone else, the wife held all the leverage. Her attorney could refuse to settle unless the husband provided a massive alimony payment to avoid a public trial on his adultery. But under no fault, that leverage vanished. This led to a historical trend where women, in particular, saw a significant drop in their standard of living post-divorce. Attorneys realized they needed a new way to protect their clients' financial futures. which led to the professionalization of asset valuation. By the early 1980s, the battlefield shifted to the definition of what constitutes an asset. This is where we see the landmark case of O'Brien v. O'Brien in 1985, a case that every law student still studies today. Michael O'Brien was a medical student, and his wife Loretta worked as a teacher to support them while he finished his degree. Shortly after he became a licensed physician, he filed for divorce. At the time, there were almost no tangible assets to divide. There was no house, no large savings account, and no investments. There was only Michael's medical license. Loretta's attorney made a radical argument that the medical license itself was marital property because it was acquired through the joint efforts of the couple. The court agreed, ruling that the enhanced earning capacity provided by the license was an asset subject to distribution. This changed everything. It meant that a divorce attorney wasn't just looking at bank statements. They were looking at the potential future value of a person's career. Imagine if a modern 2026 attorney were handled that case today. They would use sophisticated software to project Michael's earnings over the next 30 years, adjusted for inflation and market volatility, and then discount that to a present value. In the 1980s, lawyers had to do this with manual spreadsheets and expert testimony from economists. This era marked the rise of the forensic accountant as a permanent fixture in the divorce process. Attorneys began to form strategic partnerships with financial experts who could perform a lifestyle analysis. This involved looking at the couple spending over a 5-year period to prove that one spouse was hiding income, or that the marital estate was larger than reported. The attorney's job became a hunt for hidden gold. As the financial battles intensified, so did the conflict over children. Before the 1970s, the U.S. legal system largely followed the tender years doctrine. This was a legal presumption that during a child's young years, usually under 7, the mother was the naturally superior caregiver. Fathers were rarely awarded custody unless they could prove the mother was truly unfit. However, as gender roles shifted and more women entered the workforce, attorneys began to challenge this doctrine. It was replaced by the best interests of the child standard. On the surface, this sounds like a positive, more holistic approach. In practice, it turned custody into a subjective war zone. Without a clear presumption of who should get the kids, attorneys had to hire a new army of experts: child psychologists, social workers, and guardians ad litem. If you were a father in the late 1980s seeking joint custody, your attorney had to build a case that you were just as involved in the daily minutiae of parenting as the mother. This meant documenting every doctor's visit, every school conference, and every bedtime story. The legal process became an invasive deep dive into the most private moments of family life. Potential outcomes for these cases were often unpredictable, leading to a rise in scorched earth litigation tactics where attorneys would use psychological evaluations to undermine the other parent's credibility. We also have to look at the rise of the prenuptial agreement during this period. Initially, prenups were seen as the province of the ultra-wealthy or the cynical. But as divorce rates climbed and attorneys saw the absolute carnage that financial litigation could cause, they began to market prenups as a form of insurance. They moved from being defensive documents to strategic planning tools. An attorney in 1990 would advise a client that a prenup isn't about planning for failure. It's about defining the rules of the game while everyone is still playing nice. This created a new subspecialty within family law: the drafting of complex, bulletproof agreements that could withstand the scrutiny of a judge 20 years down the line. By the time we hit the mid-1990s, the divorce attorney had become a cultural icon, often portrayed in film and television as a ruthless, high-priced shark. This was the era of the first multi-billion-dollar divorces where the stakes were so high that the legal fees alone could fund a small town. These high-stakes cases set the precedents for how stock options, executive bonuses, and intellectual property would be treated in the average American household. The attorney was no longer just a legal representative. They were a crisis manager. They had to manage the media, the client's emotional volatility, and the massive logistical burden of a trial that could last months. But as the 20th century closed, a new technology was quietly emerging that would completely upend the discovery process and give attorneys more data than they ever knew what to do with. The paper trail was about to become a digital highway, and the way lawyers found the truth was about to change forever. We are moving into an era where a single deleted email or a GPS coordinate on a cell phone could win or lose a $50 million settlement. How did the arrival of the internet and social media transform the divorce attorney into a digital detective? What happened when the first high-profile Silicon Valley divorces forced the courts to value companies that had no physical assets, only users and code? And most importantly, how did the legal system react when the very definition of family began to expand through the legalization of same-sex marriage, creating entirely new categories of litigation? In the next part, we dive into the digital revolution of the 2000s and the birth of the celebrity superlawyer. The year 2000 arrived with the massive cultural anxiety of the Y2K bug. But for the American divorce attorney, the real disruption wasn't a computer glitch. It was the sudden, overwhelming ubiquity of the sent folder. As we moved into the first decade of the new millennium, the discovery process, the legal phase where both sides must turn over documents and information, underwent a transformation so radical it rendered the previous 90 years of practice nearly unrecognizable. Before this digital shift, a divorce attorney spent months sifting through physical bank statements, credit card slips, and handwritten letters found in the back of desk drawers. By 2004, that same attorney had to become a digital forensic strategist. The smoking gun was no longer a lipstick stain on a collar. It was a metadata timestamp on an email sent at 3 in the morning. Imagine if you are a high-level executive named David in 2006. You believe your private life is secure because you use a separate, password-protected laptop and an encrypted webmail service. However, your wife's attorney is part of a new breed of legal professional who understands the concept of digital permanence. This attorney doesn't just ask for your bank records. They file a motion for a mirror image of your hard drive and subpoena your internet service provider for login logs. Historical trends from this era show a massive spike in the use of computer forensic experts as expert witnesses. These specialists could recover deleted files that David thought were gone forever, revealing hidden offshore accounts or a second life that directly impacted the distribution of marital assets. The attorney's role transitioned from a storyteller to a data miner, where the ability to navigate complex electronic storage systems became just as important as the ability to cross-examine a witness in court. This period also saw the birth of the celebrity superlawyer as a mainstream cultural phenomenon. Names like Laura Wasser in Los Angeles or Raoul Felder in New York began to appear in headlines as frequently as their famous clients. These attorneys realized that in the age of the 24-hour news cycle and the rise of digital tabloids like TMZ, a high-stakes divorce was no longer just a legal battle, it was a brand management crisis. The strategy shifted toward the silent rollout. A top-tier attorney in 2008 would advise their high-net-worth client to file for divorce on a Friday afternoon before a holiday weekend to bury the lead, while simultaneously coordinating with publicists to release a carefully crafted joint statement about mutual respect and privacy for the children. The attorney became the architect of a public narrative, ensuring that the legal proceedings didn't destroy the client's endorsement deals or corporate standing. As we reached the mid-2000s, the rise of social media platforms like MySpace and eventually Facebook created a brand new category of evidence that attorneys were initially unprepared for. Imagine if a character named Jessica in 2009 is seeking primary custody of her children, claiming she is a stay-at-home parent with a stable lifestyle. However, her husband's attorney discovers a public photo album on a friend's profile showing Jessica at a high-stakes casino in another state during a time she claimed to be at home. This led to a historical trend where attorneys began to scrub their own clients' digital footprints. In the legal world of 2026, we look back at this as the Wild West of digital evidence. Today, attorneys provide clients with strict social media protocols the moment a retainer is signed. But in 2009, people were still learning that private didn't mean inaccessible to a subpoena. The legal landscape was then hit by the 2008 financial crisis, which forced divorce attorneys to operate as de facto bankruptcy and debt restructuring experts. Before the crash, the main conflict was how to divide the equity in the family home. After the crash, the attorney's job was to figure out who was responsible for the underwater mortgage. Case studies from 2010 show a surge in deferred sale agreements. In these scenarios, the attorney would draft a complex order where the divorced couple continued to co-own the home for 5 to 10 years until the market recovered, often with one spouse living in the house and the other paying a portion of the mortgage as a form of non-taxable support. This required a level of financial engineering that went far beyond traditional family law. The attorney had to predict potential outcomes of the housing market while protecting their client from the other spouse's potential future credit defaults. During this same era, the tech boom in Silicon Valley created a massive headache for valuation experts. How do you value a company that has no revenue, 50 employees, and 5 million users? Divorce attorneys in Northern California became the pioneers of venture capital accounting in the courtroom. They had to argue over the community versus separate nature of stock options and restricted stock units, RSUs. Imagine if a character named Mark joined a startup in 2004, 2 years before getting married, but the bulk of his stock vested in 2010 while he was married. His attorney had to use complex formulas like the Nelson or Hug formulas to determine exactly how many shares belonged to the marriage and how many were his alone. These formulas are still the bedrock of high-tech divorce litigation today in 2026. Simultaneously, the legal profession was grappling with the rapid evolution of civil rights. In the years leading up to the 2015 Obergefell versus Hodges decision, divorce attorneys were essentially working in a legal vacuum regarding same-sex couples. Since many states did not recognize the marriages, they also wouldn't grant the divorces. This led to the rise of collaborative law, where attorneys would bypass the court system entirely. They would draft private contracts that mimicked the effects of a divorce decree, using arbitration and mediation to divide assets, and set up custody schedules that the state courts weren't yet equipped to handle. This was a masterclass in legal innovation. Attorneys were building a shadow legal system to provide equity for clients that the formal system was ignoring. By 2012, the arrival of the smartphone transformed the divorce attorney into a literal detective. With the introduction of location sharing services and cloud-synced messaging, the amount of data available became staggering. A modern attorney in 2026 often looks back at 2012 as the year digital breadcrumbs became the primary way cases were won or lost. Attorneys began to deal with spyware, cases where one spouse would install tracking software on the other's phone. This introduced a high-stakes intersection of family law and criminal wiretapping statutes. An attorney had to be careful. If they used evidence obtained illegally by their client, they could face disbarment or even criminal charges themselves. The legal advice moved from, "What can we find?" to, "How can we find it legally so it's actually admissible?" As the decade closed, the complexity of the American family continued to outpace the legislation. We saw the rise of gray divorce, where couples over the age of 50 began divorcing at twice the rate of other age groups. For the attorney, this meant a shift in focus from child custody to pension division, Social Security derivative benefits, and long-term healthcare planning. The attorney's role became that of a retirement strategist, ensuring that a client who had been a homemaker for 40 years didn't end up in poverty because of a poorly drafted Qualified Domestic Relations Order, QDRO. But just as the legal profession felt it had a handle on digital evidence and complex financial instruments, the world shifted again. The next phase of this evolution involves a global event that forced the entire U.S. court system to close its doors and move into a virtual reality. What happened when the most contentious trials in the country moved to Zoom? How did attorneys handle the COVID divorce surge and the sudden rise of a new untraceable asset called cryptocurrency? And as we look toward the current year of 2026, how is artificial intelligence beginning to write the very motions that once took human attorneys weeks to draft? In the next part, we enter the era of the virtual courtroom and the crypto-billionaire split. The year 2020 arrived as a sledgehammer to the traditional gears of the American legal system. For nearly a century, the divorce attorney's power was centered in the courtroom, a physical space defined by mahogany benches, the silence of a gallery, and the gravity of a judge's physical presence. In March 2020, that century-old paradigm vanished overnight. As courthouses across the United States shuttered their doors, the profession faced an existential crisis. How do you litigate the dissolution of a family when the very halls of justice are closed? This was the beginning of the virtual courtroom era, a shift that transformed the divorce attorney from a theatrical orator into a technical director. Imagine if you were a character named Elena in early 2021. You are sitting in your home office, or perhaps at your kitchen table staring into a webcam. Your husband's attorney is a small tile on your screen. The judge is another tile. Your own attorney is whispering to you via a private side channel on a messaging app. This was the birth of the Zoom divorce. Historical trends from this period show that while the legal principles remained the same, the psychology of the proceedings shifted entirely. Without the intimidating atmosphere of a courthouse, some litigants became more emboldened and aggressive, while others felt a profound sense of detachment from the process. Attorneys had to learn a new set of skills: how to read a witness's body language through a grainy 720p feed, how to manage digital exhibits in real time without the benefit of handing a physical folder to a clerk, and how to maintain the sanctity of a closed door proceeding when anyone in the client's house could be listening from the hallway. This period also saw what sociologists and legal experts call the COVID divorce surge. The intense pressure of lockdowns combined with economic uncertainty and the merging of work and home life acted as a pressure cooker for struggling marriages. Data from various jurisdictions indicated a massive spike in inquiries. For the divorce attorney, this wasn't just a business boom. It was a logistical nightmare. The backlog of cases grew to unprecedented lengths. In some states, a trial that would normally take 6 months to schedule was suddenly being pushed back 2 or 3 years. This forced the profession to innovate. We saw the rapid rise of private mediation and rent-to-judge programs, where affluent couples would pay for a retired judge to hear their case privately just to avoid the years-long wait in the public system. As the world slowly reopened, a new and far more complex monster began to dominate the high-stakes divorce landscape: cryptocurrency. By 2022 and 2023, the divorce attorney had to become a student of blockchain technology. Case studies from this era illustrate the crypto husband phenomenon. A spouse who had invested heavily in Bitcoin, Ethereum, or Solana years prior, and was now attempting to hide those assets from the marital estate. Imagine if a character named Robert had a secret cold wallet, a physical USB-like device, containing $10 million in digital assets. Under the old rules of discovery, an attorney would look for bank transfers or brokerage statements. But if Robert purchased his crypto through a decentralized exchange or moved it off centralized platforms years ago, the paper trail was cold. The divorce attorney's role in 2024 and 2025 evolved into that of a digital bounty hunter. They began hiring specialized crypto-forensic firms like Chainalysis to perform what is known as on-chain tracing. This is a step-by-step process of following the movement of tokens from a known point, perhaps a single transfer from a joint bank account to Coinbase, through dozens of intermediate burner wallets until the final resting place of the funds is identified. The legal challenge wasn't just finding the money, it was valuing it. Because of the extreme volatility of crypto, an asset worth $5 million at the time of filing might be worth $2 million at the time of trial. Attorneys had to draft complex fluctuation clauses to determine who would bear the risk of a market crash during the litigation process. But as we stand here in 2026, the most disruptive force isn't the asset being divided. It's the intelligence doing the dividing. We have entered the age of AI-driven family law. In the current year of 2026, the elite divorce attorney uses artificial intelligence as a primary associate. Imagine if an attorney needs to analyze 10,000 pages of bank statements to find a pattern of marital waste, perhaps a spouse spending money on a secret paramour or a gambling habit. In 2010, this would have taken a team of paralegals weeks of manual labor and cost the client tens of thousands of dollars. Today, in 2026, the attorney uploads the data into a secure, legally trained LLM that can identify every anomalous transaction in less than 60 seconds. AI is also being used to predict potential outcomes with startling accuracy. By feeding the last 10 years of a specific judge's rulings into a predictive model, an attorney in 2026 can advise their client on the exact percentage of likelihood that they will receive a specific alimony amount or a certain custody schedule. This has fundamentally changed the nature of settlement negotiations. When both sides have access to the same data-driven predictions, the poker game of litigation loses its edge. The attorney's value has shifted from knowing the law, which the AI knows perfectly, to managing the human element. The modern attorney is now a high-level negotiator and emotional strategist, using data as a shield and empathy as a bridge. However, this technological leap has created a new digital divide. While high-net-worth individuals can afford the AI-augmented legal experience, the average American is often left navigating a system that is still catching up. We are seeing the rise of DIY divorce platforms that use basic algorithms to help couples file their own paperwork. This is a double-edged sword. While it increases access to justice, it also leads to significant errors in complex areas like pension division or tax liability. A divorce attorney in 2026 often spends as much time fixing bad DIY agreements as they do litigating new ones. We must also address the changing definition of a marital asset in the mid-2020s. We are no longer just talking about houses and 401ks. We are talking about digital footprints. Imagine if a couple's most valuable asset isn't their home, but their shared YouTube channel, or their joint Instagram brand with 3 million followers. How do you divide the goodwill of a digital persona? Who gets the password to the account that generates $50,000 a month in ad revenue? Attorneys are now drafting social media custody agreements, where the parenting time is replaced by posting time, and the revenue is split like a corporate dividend. As we look at the trajectory of the last 100 years, We see a profession that has moved from the shadows of morality to the cutting edge of technology. But as the tools become more sophisticated, the stakes become more personal. The data might be digital, but the pain of a family breaking apart is still very much human. We are entering an era where the law can track your every move and predict your every decision. But can it still provide justice? What happens when the AI makes a mistake that costs a parent their relationship with their child? How are the courts in 2026 handling the first generation of metaverse assets, where real estate in a virtual world is being sold for millions of dollars? And as we look toward the final chapters of this century-long saga, what is the final frontier for the divorce attorney? In the next part, we will explore the rise of the global divorce, where international laws collide, and the wealthiest citizens of the world play a high-stakes game of jurisdiction shopping to find the one court on earth that will give them exactly what they want. The battle for the venue is about to begin. The battle for the venue is the invisible foundation upon which every billion-dollar divorce is built. In the legal world of 2026, we call this jurisdictional arbitrage. For the elite American divorce attorney, the first question is never why a marriage ended, but rather where can we force this case to be heard? To understand this, you must understand that the United States does not have one set of divorce laws. It has 50 different legal laboratories, and the global landscape is even more fractured. Historical trends show that the outcome of a case can vary by tens of millions of dollars based solely on which side of a state line or an ocean the filing takes place. This is not a matter of convenience. It is a cold, calculated race to the courthouse. Imagine if you are a character named Christopher, a private equity titan based in Greenwich, Connecticut. You have a massive real estate portfolio in Florida, a family office in Manhattan, and your spouse, Amanda, spends 6 months of the year at your estate in London. Christopher knows that if the divorce happens in New York, the courts follow the principle of equitable distribution, which gives the judge massive discretion to divide assets based on what they deem fair. If the case lands in London, however, Amanda's attorney will aim for a 50-50 split of the total global wealth, including assets Christopher owned long before he even met her. In London, the starting point is equal sharing, and the English courts have earned the nickname the divorce capital of the world for their generosity toward the lower-earning spouse. Christopher's attorney in 2026 is already moving before Amanda even knows a divorce is coming. This is the race to court. In many jurisdictions, the first person to file and successfully serve the other party locks in that venue. This creates a high-stakes game of legal chess. Christopher's attorney must prove his domicile, his true, permanent legal home. They will compile a dossier of his utility bills, his voter registration where his cars are titled, and even his veterinary records for the family dog to prove that his life is centered in a jurisdiction with laws more favorable to his position, such as a state with strict separate property protections. Historical trends in the U.S. have moved from simple residency requirements to complex tests of minimum contacts. In the early 20th century, as we discussed with the Reno Cure, you just had to show up for 6 weeks. Today, the divorce attorney must navigate the Uniform Interstate Family Support Act and the Uniform Child Custody Jurisdiction and Enforcement Act. These are massive, dense frameworks designed to prevent parents from snatching children across state lines to find a friendlier judge. If Christopher tries to file in Florida because it has no state income tax and favorable alimony laws, but the children have lived in Connecticut for the last year, his attorney knows the custody portion of the case will almost certainly be sent back to Connecticut. The attorney's job is to deconstruct a family's entire life into a series of jurisdictional data points. Case studies from the last decade highlight the rise of the anti-suit injunction. This is a powerful and controversial tool where a judge in one country orders a person to stop their legal proceedings in another country. Imagine if Christopher successfully files in New York, but Amanda simultaneously files in London. Christopher's New York attorney will ask the judge to issue an order forbidding Amanda from continuing the London case. If she refuses, she could be held in contempt of court in the U.S., facing massive fines or even the seizure of her American assets. This creates a jurisdictional standoff that can last for years before the actual divorce even begins. The legal fees for this phase alone frequently exceed 7 figures because you aren't paying one lawyer. You are paying a global team of specialists who must coordinate in real time across different time zones. By 2026, this has become even more complicated due to the digital nomad lifestyle. Imagine if a couple has no fixed home, moving between high-end rentals in Portugal, Bali, and Austin, Texas. An attorney in this scenario must perform a deep dive into the habitual residence test. This involves looking at where the couple intended to stay, where they paid taxes, and where they centered their social and professional lives. In the current year, AI-driven tools allow attorneys to map out every flight, every credit card transaction, and every geolocated social media post to build a heat map of residency. If you spent 183 days in a specific country, you might have inadvertently given that country's courts the power to dissolve your multi-billion-dollar marriage and tax your global earnings. We also see the rise of the international asset shield. In the high-stakes world of the 2020s, a divorce attorney isn't just looking at bank accounts. They are looking at offshore trusts in the Cook Islands or Nevis. These jurisdictions are designed to be impenetrable. They don't recognize U.S. court orders. A U.S. divorce attorney must decide whether it is worth the millions of dollars in potential costs to pursue these assets. Historical trends show that unless the amount hidden is staggering, the attorney will instead use the existence of the offshore trust as leverage, arguing that since one spouse has access to secret millions, the other spouse should get 100% of the visible assets like the family home and the domestic investment accounts. The Hague Convention on the Civil Aspects of International Child Abduction is the most high-stakes part of this global puzzle. When a marriage collapses and one parent takes the children to another country without consent, the attorney must initiate a Hague proceeding. This is a specialized, lightning-fast legal action where the only goal is to return the child to their country of habitual residence. It is not a custody hearing. The judge doesn't care who is the better parent. They only care about where the child was living before the move. Attorneys in these cases must act within days. A delay of just a few weeks can be used by the other side to argue that the child has already settled into a new environment, potentially trapping the child in a foreign legal system forever. In 2026, we are also seeing the emergence of forum shopping for digital assets. Some jurisdictions are much more advanced in how they treat cryptocurrency and NFTs in a divorce. An attorney representing the tech-savvy spouse might try to pull the case into a jurisdiction like Wyoming or Switzerland, which have established legal precedents for the valuation and transfer of digital tokens. Conversely, the attorney for the spouse who was left in the dark about the family's crypto holdings will push for a venue with aggressive discovery laws that allow for the subpoenaing of centralized exchanges and the use of forensic blockchain analysts. This globalized era of divorce has created a new class of super attorney, the private international law expert. These individuals don't just know the law of their state. They understand the interplay of treaties, the nuances of civil law versus common law systems, and the psychological tactics of different legal cultures. They are the grandmasters of the venue, knowing that if they win the battle for the courtroom, they have already won 70% of the war. They understand that potential outcomes are determined by the soil you stand on when the gavel falls. As we look at how these massive international battles are fought, a new question arises. What happens when the assets aren't just hidden in a bank account in the Cayman Islands, but are hidden behind layers of corporate shells and complex intellectual property assignments? How does a divorce attorney value a brand that only exists on a screen, or a patent for a technology that hasn't been released yet? And most importantly, as we move into the next phase of our masterclass, how did the rise of the prenuptial agreement go from a tool for the paranoid to a mandatory requirement for anyone entering the 2026 economy? In the next part, we will peel back the layers of the ironclad prenup. We will look at the exact clauses that attorneys use to waive alimony, protect premarital wealth, and even dictate the behavior of a spouse. We will explore the lifestyle clauses that cover everything from weight gain to social media posts. And we will reveal why even the most carefully drafted agreement can sometimes be shredded in a matter of minutes by a skilled litigator. The era of the pre-planned exit is here. The era of the pre-planned exit is here. And it has fundamentally redefined the marriage contract from a sacred vow into a sophisticated financial instrument. To understand the 2026 landscape of the prenuptial agreement, we have to look back at the historical trends that brought us to this point. For much of the 20th century, prenuptial agreements were viewed by the American legal system with deep suspicion. Courts frequently struck them down on the grounds that they were against public policy because they were seen to facilitate or even encourage divorce. If you were an attorney in 1950, drafting a prenup was a gamble. You were asking a judge to enforce a contract that essentially planned for the failure of a social institution. But as divorce rates climbed in the 1970s and 80s, the legal system underwent a seismic shift toward the principle of freedom of contract. The landmark turning point was the 1983 Uniform Premarital Agreement Act, which provided a standardized framework that many states adopted, making these agreements far more predictable and enforceable. Imagine if you are a character named Michael in 2026. Michael is a 34-year-old software engineer who has just secured Series B funding for a startup that utilizes decentralized AI for medical diagnostics. He is engaged to Sarah, a highly successful digital brand consultant with 5 million followers and a significant portfolio of residential real estate. In the world of 2026, Michael's attorney doesn't just see a wedding. They see a massive merger of two distinct corporate entities. The attorney's job is to create a digital and financial firewall between Michael's intellectual property and Sarah's established real estate empire. This is no longer just about who keeps the house. It is about protecting the future valuation of an algorithm that hasn't even been fully coded yet. The modern prenuptial agreement in the US is built on 3 pillars: full disclosure, independent counsel, and the absence of duress. If an attorney fails to execute any of these steps perfectly, the entire document can be shredded in minutes during a future litigation. Let's look at the first pillar: full and fair disclosure. In 2026, this is the #1 reason prenups fail. Historical trends show that if one party hides even a single brokerage account or fails to accurately value a retirement pension, a judge can throw the entire agreement out as fraudulent. Michael's attorney must facilitate a process where every single asset, from physical property to fractional shares of cryptocurrency, and even the potential value of Sarah's brand sponsorships, is listed in an exhaustive exhibit attached to the contract. In the 2026 legal market, attorneys often use automated discovery tools that sync with the client's financial institutions to ensure that the disclosure is 100% accurate at the moment of signing. The second pillar is independent counsel. For an agreement to be ironclad, both Michael and Sarah must have their own separate attorneys. If Michael's lawyer drafts the document and Sarah simply signs it without her own legal representative reviewing it, the agreement is essentially a ticking time bomb. Case studies from high-net-worth divorces in the early 2010s demonstrated that courts are increasingly protective of the spouse with less bargaining power. If the attorney for the wealthier spouse even pays the legal fees for the other spouse's attorney, it can raise questions of a conflict of interest. In 2026, the gold standard is for each party to pay their own counsel from their own separate funds to ensure there is no hint of undue influence. Then there is the issue of timing and duress. Imagine if Michael presents the prenup to Sarah 3 days before the wedding, while the flowers are being delivered and the guests are arriving. This is a classic example of legal duress. A skilled litigator in a future divorce would argue that Sarah was under such immense social and emotional pressure that her signature wasn't truly voluntary. To avoid this, 2026 attorneys follow what is known as the 60-day rule. They insist that the final version of the agreement be signed at least 2 months before the ceremony. This ensures that both parties had ample time to reflect, negotiate, and walk away if they didn't like the terms. Now, let's go deeper into the specific clauses that define the 2026 experience. We are seeing a massive rise in lifestyle clauses. These go far beyond the division of bank accounts. Imagine a social media non-disparagement clause. In an era where a single viral post can destroy a person's professional reputation, attorneys are drafting agreements that impose massive financial penalties if one spouse posts negative content about the other during or after the marriage. We also see infidelity clauses, often called cheating penalties. While these are difficult to enforce in some no-fault states like California, in other jurisdictions, they are being used to create a contractual fault where the law doesn't provide one. If Michael is proven to have been unfaithful, the prenup might dictate that he forfeits a specific lump sum or a larger percentage of the marital residence. One of the most complex areas of the 2026 prenup is the sunsetting clause. This is a provision that states the agreement will expire or be significantly modified after a certain number of years, often 10, 15, or 20. The logic is that the longer a marriage lasts, the more the lives of the spouses become entwined, and the less fair it is to hold them to a contract signed when they were 25. An attorney must carefully calculate these milestones. Perhaps after 10 years, Sarah becomes entitled to 20% of the appreciation of Michael's company, and after 20 years, the waiver of alimony is completely voided. This creates a sliding scale of potential outcomes that reflects the evolving nature of a long-term partnership. We must also discuss the rise of the post-nuptial agreement. This is a contract signed after the couple is already married. Historical trends indicate that postnups often arise when a couple hits a rough patch but isn't ready to divorce. Imagine if Michael's startup experiences a massive liquidity event 3 years into the marriage. Sarah might feel that the original prenup no longer reflects their current reality. They might sign a postnup to provide her with more security in exchange for her staying in the marriage and supporting the growth of the business. However, postnuptial agreements are even more strictly scrutinized by judges than prenups. Because the parties already owe each other a fiduciary duty as husband and wife, the attorney must be even more diligent in ensuring the agreement is substantively fair at the time it is signed. But even the most meticulously drafted agreement can be attacked through the doctrine of unconscionability. This is the nuclear option for a divorce attorney. An agreement is unconscionable if it is so one-sided that it shocks the conscience of the court. Imagine if the prenup leaves Sarah completely destitute, while Michael retains $50 million. Even if Sarah signed it voluntarily with her own lawyer, a 2026 judge might refuse to enforce it on the grounds that it would force Sarah onto public assistance while Michael lives in luxury. The attorney's job is to find the sweet spot, protecting the client's wealth without making the agreement so harsh that it becomes unenforceable. As we move into the final chapters of this evolution, the divorce attorney is no longer just litigating the past, they are engineering the future. But what happens when the digital world moves faster than the ink on the contract? How do you handle assets that didn't exist when the prenup was signed, like virtual land in a metaverse that became worth millions overnight? And as we look toward our next deep dive, we have to ask, how did the role of the attorney change when the battle shifted from the bank account to the bedroom? In an era of increasing privacy concerns and digital surveillance, the way attorneys prove conduct is changing. How are attorneys in 2026 using AI to analyze a spouse's behavioral patterns to argue for a larger share of the estate? What happens when a smart contract automatically triggers a divorce settlement the moment a specific condition is met? In the next part, we will explore the intersection of big data and private lives, where every text, every location ping, and every heartbeat recorded by a smartwatch becomes a weapon in the hands of a skilled matrimonial litigator. The surveillance state has entered the family home, and the lawyers are the ones holding the data. The surveillance state has not just entered the family home. It has taken up permanent residence in the pockets, on the wrists, and inside the very walls of every modern American household. For the divorce attorney in 2026, the traditional private investigator, once the archetype of the industry, has been largely replaced by the Internet of Things. In the early 20th century, a lawyer needed a man in a trench coat to follow a spouse to a motel. By the early 21st century, they needed a forensic specialist to check a desktop computer. Today, the modern matrimonial litigator is a master of digital exhaust, the trail of data that we all leave behind simply by existing in a connected world. This shift has moved the focus from what a person says to what their devices prove they did. Imagine if you are a character named Thomas. Thomas is a high-earning corporate executive in Chicago who is currently embroiled in a high-stakes alimony dispute. Thomas claims that due to a recent and debilitating back injury, he can no longer perform the duties of his high-stress job and certainly cannot maintain the lifestyle his spouse, Rachel, is demanding in spousal support. In 1995, Rachel's attorney would have had a difficult time proving otherwise without expensive medical experts and perhaps a lucky photo of Thomas lifting groceries. In 2026, Rachel's attorney simply subpoenas the data from Thomas's high-end smartwatch and his connected fitness equipment. Historical trends show that biometrics are becoming the ultimate truth-tellers in the courtroom. When the data reveals that Thomas has been maintaining a heart rate consistent with high-intensity interval training 4 times a week and hitting a step count of 12,000 per day, his claim of physical incapacitation evaporates. The attorney doesn't need to argue. They simply present the heat map of Thomas's physical activity. This is the new frontier of evidentiary deep diving. Attorneys are now looking at the smart home as a digital witness. Consider the role of the smart thermostat or the smart refrigerator in a domestic trial. If a spouse claims they have been the primary caregiver, residing in the family home and managing the children's schedules, but the smart home logs show that the house was in away mode from 8 a.m. to 6 p.m. every day for 3 months, the narrative of the stay-at-home parent begins to crumble. We see case studies where Nest camera logs, Ring doorbell footage, and even the logs from a smart washer and dryer are used to establish the true timeline of a marriage's final months. If the laundry is only being done at 2 a.m. on Tuesday nights, and the smart lock records a specific guest code being used every time the primary spouse is out of town, the divorce attorney has a chronological map of conduct that is nearly impossible to refute. The legal strategy in 2026 has evolved to treat every location ping as a potential exhibit. Imagine if a spouse, Sarah, is under a court order to stay away from her ex-husband's new residence. She claims she has followed the order perfectly. However, her connected vehicle, a Tesla Model S, records every GPS coordinate in every stop. Her attorney knows that the vehicle's internal logs are a black box of her movements. Car's autopilot data shows it was parked 2 blocks away from the prohibited residence for 4 hours on a Saturday night. The attorney for the other side has all the evidence they need for a contempt of court filing. The attorney's job is no longer just to ask where you were, but to ask the car where it took you. However, this level of surveillance brings us to a complex intersection of the law, the Electronic Communications Privacy Act, and the concept of the expectation of privacy. In 2026, the elite divorce attorney must be an expert in what constitutes legal discovery versus illegal hacking. Historical trends indicate that many cases are won or lost based on how the evidence was obtained. If Rachel in our previous example accessed Thomas's smartwatch data because they still shared a family iCloud account, the evidence is likely admissible. But if she used a third-party spyware app to bypass his security, her attorney faces a catastrophic problem. Not only could the evidence be suppressed, but Rachel could face criminal charges, and her attorney could face a bar investigation. The modern attorney's advice to a client is no longer seek out the truth, but rather, let me show you how to find the truth without breaking federal wiretapping laws. We are also seeing the rise of the digital lifestyle analysis. In the past, an attorney would hire an expert to look at bank statements to prove a spouse was spending money on a secret life. In 2026, they look at the Uber and Lyft history, the DoorDash receipts, and the Amazon purchase logs. If a husband claims he is broke and cannot pay child support, but his DoorDash history shows 5 nights a week of high-end sushi deliveries to an address that isn't the marital home, the attorney has proven 2 things at once. He has undisclosed income, and he has a secret residence. This granular level of detail allows for a potential outcome where the judge imputes income to the husband, essentially telling him the court knows he has the money because the data says he's eating like a king. Even the most private spaces are no longer secure. Smart speakers like Alexa and Google Home are constantly listening for their wake words. While these companies claim they do not record private conversations, attorneys have successfully subpoenaed the transcripts of voice commands. If a spouse shouts a command to Alexa in the middle of a domestic dispute, that recording becomes a time-stamped, audiovisual record of the emotional state and conduct of the parties. Case studies from 2024 and 2025 show that these recordings are increasingly being used in custody battles to prove a parent's volatile temperament. Imagine if an attorney can play a recording of a parent losing their temper in front of the children, captured accidentally by a smart speaker in the kitchen. It is a level of transparency that earlier generations of lawyers could only dream of. The role of the attorney has shifted toward being a synthesizer of this massive data set. They use AI tools to cross-reference the Tesla logs with the Amazon receipts and the heart rate data from the smartwatch to build a comprehensive theory of the case. This is forensic storytelling at its most advanced level. By the time a case reaches trial in 2026, the attorneys often know more about the daily habits of the opposing party than that person knows about themselves. They know what they ate, where they went, how fast they drove, and how well they slept. But as the data becomes more invasive, the psychological toll on the litigants increases. The feeling of being constantly watched by your own home creates a new kind of trauma in the divorce process. Attorneys are now seeing a spike in what they call digital domestic abuse, where one spouse uses the smart home system to harass the other, changing the locks remotely, turning the lights on and off, or blasting music at 3 a.m. This has forced the legal system to create new types of restraining orders specifically for the digital realm. The divorce attorney in 2026 must be prepared to litigate the ownership of the digital infrastructure of the home, just as fiercely as the home itself. As we conclude this exploration of the surveillance state in the family home, we must realize that we have only scratched the surface of how technology is deconstructing the private life. The data is everywhere, and the lawyers are the ones who have learned how to read the code. But what happens when the conflict moves from the data on the screen to the most fundamental part of the human experience? The relationship between a parent and a child. How does the modern attorney handle the most heartbreaking and complex weapon in the divorce toolkit? The systematic turning of a child against a parent. In the next part, we will dive into the psychological battlefield of parental alienation. We will explore how attorneys work with forensic psychologists to identify the subtle signs of brainwashing, the role of the guardian ad litem in 2026, and the controversial legal strategies used to reunify families that have been torn apart by the bitterness of a century of conflict. The war for the mind of the child is the most high-stakes battle a divorce attorney will ever fight. The war for the mind of the child is the most high-stakes battle a divorce attorney will ever fight. To enter this psychological arena, we must understand that the legal definition of a child has shifted over the last century from a piece of property to a vulnerable participant with their own set of rights. In 1926, the law was blunt. Fathers generally held the primary right to their children as a matter of patriarchal succession. By the middle of the century, the pendulum swung to the tender years doctrine, which presumed that young children naturally belonged with their mothers. But as we stand in 2026, the attorney's role has evolved into something far more clinical and dangerous. They are now navigating the murky waters of parental alienation, a term that describes the systematic psychological manipulation of a child by one parent to reject the other. Imagine if you are a character named Mark, a dedicated father who until 6 months ago had a seamless relationship with his 10-year-old daughter, Chloe. Since the divorce filing, Chloe has suddenly become cold. She uses phrases like "Mark is financially abusive" or "Mark never prioritized our emotional safety." These are not the words of a 10-year-old. They are the echoed scripts of an adult. In the current legal climate of 2026, Mark's attorney recognizes these as the red flags of a sophisticated alienation campaign. The attorney's first move isn't a motion for more time. It is a request for the appointment of a forensic psychologist. Historical trends in the U.S. show that high-conflict custody cases now almost always involve a third-party mental health expert. These professionals are not there to provide therapy. They are there to perform a child custody evaluation. This is a grueling months-long process where the attorney must manage the flow of information to the evaluator. The evaluator conducts multiple interviews, observes the child with each parent, and administers psychological testing like the MMPI-3 to both adults. The divorce attorney's job in 2026 is to ensure that every instance of coaching or interference is documented. This is where the digital footprint we discussed earlier becomes vital. Mark's attorney will use AI-driven linguistic analysis to compare the child's text messages with the mother's text messages. If the syntax, the vocabulary, and the specific grievances match perfectly, the attorney has the digital proof of programming. The primary weapon in this battle is often the guardian ad litem, or GAL. This is an attorney or a social worker appointed by the court specifically to represent the best interests of the child. In 2026, the GAL is the eyes and ears of the judge. They have the power to enter the home unannounced, interview teachers, and review medical records. A savvy divorce attorney knows that winning over the GAL is often more important than winning over the judge. The attorney must present their client as the healthy parent, the one who encourages the child's relationship with the other side. This is the paradox of modern custody litigation. To get the child, you must prove you are willing to share the child, while simultaneously proving the other parent is trying to steal the child's affection. Case studies from the last 5 years highlight a controversial and high-stakes legal strategy: the reunification order. If the alienation is found to be severe, a 2026 judge may order a custody flip. This is the nuclear option of family law. Imagine the scene. A court officer and a transport team arrive at the mother's house. Chloe is removed from her mother's care and immediately taken to a reunification camp, a private facility where she is required to stay with her father, Mark, for several days or weeks without any contact with her mother. The mother's attorney will argue this is a violation of the child's constitutional rights and a form of state-sponsored kidnapping. Mark's attorney will argue it is the only way to break the psychological spell cast by the alienating parent. These cases are among the most expensive and emotionally draining in the legal system, with potential outcomes that can leave a family fractured for decades. Historical trends also show that attorneys are increasingly dealing with the resist-refuse dynamic. This occurs when a teenager simply refuses to go to a parent's house. In the early 20th century, a judge would have simply ordered the police to enforce the order. In 2026, judges are loath to use physical force on a 17-year-old. The attorney must instead focus on contempt of court against the favored parent. They have to prove that the mother isn't just allowing the child to stay home, but is actively or passively encouraging the defiance. The attorney will look for subtle cues. Does the mother have the child's bags packed? Does she tell the child, "I want you to go, but I can't make you"? That second phrase is a classic example of indirect alienation, where the parent gives the child the power to veto a court order. By 2026, the role of the child's own attorney has also become more prominent. Some states now mandate that children over a certain age have their own legal counsel to argue for their specific wishes, as opposed to their best interests. This creates a three-way or even four-way legal battle. The father's attorney, the mother's attorney, the JL, and the child's attorney all descend on a single household. This is the industrialization of family conflict. The divorce attorney must be a master of the long game, understanding that every move made in the courtroom will have a psychological ripple effect on the child's development. We are also seeing the rise of parenting coordinators, or PCs. These are semi-judicial officers who have the power to make immediate, binding decisions on day-to-day issues without the parties having to go back to court. If Mark and the mother can't agree on whether Chloe can attend a birthday party or get a specific haircut, the PC makes the call. The divorce attorney's role is to draft the order of appointment for the PC, defining exactly how much power they have. This is a form of private judging that has become a necessity in 2026 because the public court systems are too slow to handle the micro-conflicts of high-stress families. But even as the law becomes more specialized, a new and darker trend is emerging in 2026: the use of false allegations as a tactical maneuver. An attorney may be faced with a client who is being accused of the worst possible crimes simply to secure an ex parte order of protection, which strips them of custody before they even have a chance to speak. The attorney must move with lightning speed to debunk these claims using the digital evidence, medical forensics, and expert testimony we have analyzed throughout this masterclass. The speed of the modern world means that a reputation can be destroyed in 48 hours, and a parent-child bond can be severed in a single weekend. As we look toward the final stages of this evolution, we realize that the divorce attorney has become far more than a legal professional. They are a crisis manager, a psychological strategist, and a digital detective. But what happens when the battle ends? When the final decree is signed and the assets are divided? Does the attorney's role truly stop at the courthouse steps? And as we move into the current reality of 2026, how is the profession preparing for a future where traditional marriage itself is becoming a minority lifestyle? What happens when the concept of the family unit expands to include multi-parent households or co-parenting contracts between people who were never married? How will the divorce attorney of the late 2020s handle the dissolution of these new social structures? And in our next part, we will look at the final bill, the staggering economics of the divorce industry. We will break down exactly where the money goes, how much it really costs to win, and why the most successful attorneys are the ones who know how to stop the war before everyone is bankrupt. The business of heartbreak is about to be laid bare. The business of heartbreak is about to be laid bare, and it is a multi-billion-dollar machine that functions with the cold precision of a high-frequency trading floor. To understand the economics of the modern U.S. divorce attorney, we have to look past the mahogany desks and into the ledger of the billable hour, a system that was formalized in the mid-20th century and has since become the primary engine of legal wealth. In 1926, a divorce lawyer might have charged a flat fee for a simple uncontested decree, perhaps a few $100s. But as the legal complexity exploded, the profession adopted the 6-minute increment. In the current year of 2026, this means that every phone call, every email, and even every text message sent to your counsel is logged as 0.1 hours. If your attorney bills at $500 per hour, a 2-minute, just checking in phone call costs you $50. If they take that call, hang up, and then spend 3 minutes reading a follow-up email, you have just spent $100 before the morning coffee has even gone cold. Historical trends show that the cost of a contested divorce in the United States has outpaced inflation for 3 consecutive decades. Today, the average contested divorce can range from $15,000 to over $100,000 per spouse, depending on the complexity of the assets. But for the elite tier, the numbers are staggering. Imagine if you are a character named Alexander, a senior partner at a tech-focused venture capital firm in Silicon Valley. His wife, Catherine, has spent 20 years building a nonprofit foundation and managing their 3 children. Their marital estate is valued at $85 million, including complex stock options, carry interest in multiple funds, and a collection of fine art held in a domestic asset protection trust. In 2026, Alexander's attorney will likely require an initial retainer of $50,000 to $100,000 just to open the file. This is not the total cost. This is merely a down payment held in an escrow account. Alexander's attorney will then implement what is known as an evergreen retainer. This is a contractual requirement that the client must maintain a specific balance in the trust account at all times. If the balance dips below $25,000 due to monthly billing, Alexander must top it off immediately or the firm has the right to withdraw from the case. This ensures that the law firm is never in the position of being an unsecured creditor to its own client. Step by step, the money begins to bleed out into a vast ecosystem of experts. The attorney is the general contractor of the divorce, but they must hire an army of subcontractors. First, there is the forensic accountant. To value Alexander's venture capital interests, a specialist is brought in at $600 per hour. This expert will spend 40 to 60 hours performing a DCF or discounted cash flow analysis, scouring tax returns, and auditing the internal rate of return on various funds. The cost for this single report? $32,000. Then comes the vocational expert. Catherine hasn't worked in the for-profit sector in 2 decades. Alexander's attorney wants to limit his alimony exposure by proving that Catherine has the earning capacity to support herself. The vocational expert is hired to interview Catherine, review her resume, and analyze the 2026 job market. They will produce a report stating that Catherine could potentially earn $120,000 as a corporate consultant. This report costs $7,000, and the expert will charge another $3,000 for every half day they spend waiting to testify in court. We haven't even mentioned the custody evaluators, the private investigators, or the digital forensic teams we discussed in previous parts. By the time Alexander and Catherine reach the discovery phase, they may have collectively spent $300,000, and they haven't even seen a judge yet. Case studies from high-stakes litigation show a phenomenon known as the winner's curse. This occurs when a party spends more to secure an asset than the asset is actually worth. Imagine if Alexander and Catherine are fighting over a vacation home in Aspen with $2 million in equity. If the legal fees to litigate the ownership of that home reach $500,000 per side, they have effectively spent half the value of the house just to decide who gets to keep it. Attorneys in 2026 often use AI-driven cost-benefit models to show clients the potential outcomes of continued litigation, but the emotional volatility of a divorce often overrides financial logic. Historical trends indicate that as the conflict increases, the rationality of the spending decreases. People will spend the children's college fund to win a dining room table, not because of the table's value, but because the table represents a psychological victory over the other party. In response to these astronomical costs, we have seen the rise of litigation funding, the venture capital of divorce. In the 2020s, companies began offering non-recourse loans to the lower-earning spouse. Imagine if Catherine has no access to the marital accounts because Alexander has frozen them. A litigation funder will look at the case, analyze the potential outcome of her settlement, and invest in her divorce by paying her legal fees and expert costs. In exchange, the funder takes a percentage of her final settlement or a high-interest return. This has leveled the playing field, but it has also added another layer of commission to the business of heartbreak. The divorce attorney in 2026 must now coordinate not just with experts, but with financial backers who are treating the dissolution of a family like a business transaction. However, the current year of 2026 has introduced a new variable: AI efficiency versus value-based billing. Traditionally, lawyers made more money the longer a case took. But with AI tools now doing 80% of the document review and legal research in seconds, the billable hour is under threat. Elite firms have started shifting toward value-based billing or project-based fees for certain phases of the case. They might charge a flat $50,000 for the discovery phase, regardless of how many hours the AI spends processing data. This ensures the firm maintains its profit margins, while the client theoretically sees a faster resolution. But beware the AI review fee, a new line item on the 2026 legal bill where attorneys charge a premium to verify the work done by their digital associates. What many people fail to realize is that the final bill from the attorney is often just the beginning of the financial fallout. There is the tax impact of liquidating assets to pay for the divorce itself. There is the loss of economies of scale when one household becomes two. And then there is the post-decree litigation. Historical trends show that 10 to 15% of cases return to court within 3 years for modifications of support or custody. The divorce attorney is often a lifetime partner for the wealthy, returning every few years to recalibrate the financial machinery as lives and incomes change. The most successful attorneys in 2026 are those who can navigate this without bankrupting the client, realizing that a dead client is a client who can no longer pay the next retainer. But as the money flows and the ledger balances, there is one final ultimate disruption that the legal world is not prepared for. We have seen how the law handles houses, stocks, and even cryptocurrency. But what happens when the very nature of a person changes? What happens when an attorney is asked to divide the assets of a marriage where one party doesn't even have a physical body, or where the marital residence exists only in a digital cloud? As we move into the final part of our century-long deep dive, we are looking at the future of the dissolution, an era of decentralized autonomous marriages, smart contract settlements, and the final controversial frontier of the AI spouse. How will the 2030s and beyond redefine the divorce attorney out of existence, or transform them into something entirely post-human? We are about to look at the end of the courtroom as we know it. In the final part, we explore the legal revolution that is currently being coded in the shadows, where the final decree is no longer a piece of paper, but a line of code that executes automatically the moment the heart breaks. The century of the divorce attorney is ending, and the era of the algorithmic exit is about to begin. The algorithmic exit is not a distant science fiction concept. It is the logical conclusion of a 100-year march toward the quantification of human relationships. As we stand in the year 2026, we are witnessing the first generation of couples who view the divorce attorney not as a person to be hired, but as a legacy system to be bypassed. To understand where we are going, we have to look at the emergence of the smart marriage contract. Imagine if you are a character named Julian, a systems architect living in a tech hub in 2028. Julian and his partner Elena decide to marry, but they do not merely sign a marriage license at City Hall. Instead, they deploy a decentralized autonomous marriage contract on a Layer 2 blockchain. This contract contains all the parameters of their union: the definition of separate versus community property, the specific milestones for the vesting of marital assets, and the triggers for dissolution. In this scenario, the divorce attorney is replaced by an oracle. In blockchain terminology, an oracle is a data feed that provides real-world information to a smart contract. Julian's contract is linked to their joint bank accounts, their brokerage firms, and even their property titles. If Julian and Elena decide to end the marriage, they don't file a petition with the court. They both provide their digital signatures to a dissolution function within the code. Instantly, without a single human intervention, the algorithm executes. It calculates the current market value of their cryptocurrency holdings, the equity in their virtual and physical real estate, and the projected value of their professional licenses. Within seconds, the funds are routed to their individual wallets. This is the programmatic distribution of wealth, and it represents a total departure from the interpretive, high-friction world of the 20th century courtroom. Historical trends suggest that this transition will happen first among the digital native elite, before trickling down to the general public. Case studies from early adopters in 2025 show that these self-executing settlements eliminate the winner's curse and the astronomical legal fees we analyzed in the previous part. But this shift introduces a terrifying new set of variables. What happens if the code has a bug? In a traditional system, an attorney can file a motion to correct a clerical error. In the world of the algorithmic exit, code is law. If the contract was programmed with a flawed valuation formula, the transfer is immutable. This has given rise to a new type of professional, the matrimonial code auditor. These individuals are part lawyer and part software engineer, and their job is to ensure that the smart contract accurately reflects the intent of the parties before the wedding ever takes place. We must also address the most complex frontier of the late 2020s, the division of digital identity. Imagine if Sophia, a top-tier virtual influencer in 2027, divorces her manager and husband. Sophia's most valuable asset is her digital twin, a high-fidelity, AI-driven avatar that generates millions in revenue through automated streaming and brand deals. Who gets the rights to the training data that makes the avatar sound and act like Sophia? Does the husband have a claim to the intellectual property of her digital likeness because it was developed during the marriage? A divorce attorney in 2026 is already grappling with these questions, but the future points toward a system where digital assets are sharded. The ownership of the avatar might be split into tokens, with the revenue stream automatically divided between the ex-spouses by a smart contract. This is a level of forensic complexity that makes the old battles over a family home seem quaint. As we move deeper into the 2030s, the physical courtroom may become a relic of a slower era. We are seeing the rise of virtual arbitration centers where disputes that cannot be settled by code are handled by AI judges. These are not just simple bots. They are high-level reasoning engines trained on a century of case law, from the Reno Cure era to the most recent crypto valuation precedents. Imagine if Julian and Elena have a dispute over a sentimental physical asset that wasn't included in the smart contract. They enter a virtual reality mediation room. The AI judge analyzes their historical communications, their spending patterns, and even their biometric stress levels during the negotiation to determine a fair outcome. This system is designed for maximum efficiency and zero emotional bias. Historical trends indicate that as these AI systems become more accurate, the public's trust in human judges, who are subject to fatigue, personal prejudice, and political pressure, will continue to decline. But there is a darker side to the algorithmic exit. If a marriage is governed by code, then the code can be weaponized. We are already seeing the emergence of predatory programming in high-net-worth prenups. An attorney for a wealthier spouse might hide a poison pill in the smart contract, a line of code that triggers a total forfeiture of assets if certain difficult-to-define behavioral conditions are met, verified by the surveillance state tools we discussed in Part 7. This moves the battle from the courtroom to the compiler. The divorce attorney of the future won't be a charismatic orator. They will be a cybersecurity expert defending their client's financial life from malicious code. We must also consider the rise of the AI companion and how it will redefine the very concept of divorce. In the late 2020s, as AI becomes more sophisticated and capable of genuine emotional labor, we will see the first legal cases involving the dissolution of relationships between humans and their digital partners. While this may sound far-fetched today in 2026, the historical trend of legal expansion suggests that the law eventually catches up to social reality. If a person invests significant marital funds into a high-end, personalized AI companion, is that considered marital waste? If they divorce their AI partner, who gets the data that represents years of shared history and emotional intimacy? The divorce attorney will be forced to litigate the value of a digital soul. As we conclude this century-long masterclass, we see a profession that has moved through three distinct phases. The first was the era of morality, where the attorney was a guardian of social norms, requiring proof of sin to allow an exit. The second was the era of the adversary, where the attorney was a high-priced gladiator in a war over assets and children. The third, the era we are entering now, is the era of the architect. The modern matrimonial expert is an engineer of outcomes, using data, code, and psychology to build a framework for a family's end before the end even begins. The century of the divorce attorney in the U.S. has been a mirror held up to the American heart. It has reflected our changing views on gender, wealth, privacy, and the definition of a life well lived. From the staged adultery photos of the 1920s to the self-executing smart contracts of the 2030s, the goal has remained the same: the search for a way to untangle two lives with some semblance of justice. But as the tools become more automated and the lawyers become more like engineers, we have to ask ourselves, what is lost when the human element is removed? Can an algorithm ever truly understand the best interests of a child, or the subtle weight of a 20-year sacrifice? The battle for the future of the American family is no longer being fought just in the halls of justice. It is being written in the lines of code that will govern our most intimate choices. The era of the high-stakes, high-drama trial may be ending, but the complexity of human conflict is merely finding new ways to express itself. We have looked at the past, we have analyzed the present, and we have glimpsed the future. The question now is not whether the system will change, but how you will navigate it when the code of your own life requires a rewrite. Is the decline of traditional marriage and the rise of the algorithmic exit a sign of progress, or are we losing the very friction that makes human commitment meaningful? What happens to the concept of justice when it is reduced to a mathematical certainty? And as we look toward the next century, will the divorce attorney even exist, or will they have become a footnote in the history of a civilization that finally learned how to automate heartbreak? The deep dive into the business of the end is complete, but the story of the next century is just being coded. What is the next evolution in the way we define, protect, and dissolve the human bond in a world that is increasingly post-physical? In our next series, we will explore the hidden legal structures of the global elite, from the sovereign individual to the rise of private cities, and how the law of the future is being built for those who can afford to leave the system behind. The exit is just the beginning.